I think we're ready to start. Just before we hear any of the evidence, we're going to hear from Honourable Mark Vanterpool this morning. Just 2 points to do with his evidence. Firstly, Honourable Vanterpool, you wrote through your lawyers asking about the cabinet minutes for the relevant period. We'll come on to what the relevant period is. Having done that, we have contacted the Attorney General, and cabinet minutes have been disclosed to us, and we've put them onto the Go Anywhere site so that you will have them. We've only just received them. We haven't looked at them yet, and you certainly won't have looked at them yet. What I'm going to suggest to you and Mr. Fraser is that we will deal with the evidence this morning, and then once you've had a chance to look at those, perhaps you can come back to us by the end of the week, 4 p.m. on Friday, with anything further that you might want to say as a result of looking at the cabinet minutes. Sure. Yes, is that good? Okay. Secondly,
Mr. Commissioner, if I may.
Certainly.
Is this on?
No, you just turned it off.
Oh, thank you.
I think that's it. Is that on?
Yes.
Yes, thank you very much.
Yeah, Mr. Commissioner, if I may.
Yes.
In my testimony, I may refer to certain dates, not necessarily contents of cabinet meetings.
Certainly.
Is that okay?
Yes. Yes.
If I may, yeah, thank
yes.
You. Thank you.
Yes, because you're right. I should have added that the Attorney General, although these cabinet minutes have been disclosed, and she's content for you to see them as a former cabinet minister, she's not willing for them to be disclosed in a public hearing at the moment. But as I say, for practical reasons, that would be difficult in any event. But we'll deal with it in the way that I've suggested.
But I may, from time to time, I may reference dates.
Fine.
Without content.
Yes. No,
I appreciate that.
That's fine. Thank you very much.
Thank you.
And in any event, the Solicitor General is here. There's a 3-minute delay. So if we go into areas which she considers we shouldn't go into, she can stop us.
Yes, appreciate it.
Secondly, Mr. Denniston Fraser has sent in some legal submissions on what we're going to be dealing with today. What we'll do, Mr. Fraser, thank you for those, and then we can deal with any oral submissions at the end. Firstly, as to whether you want to add anything to those, and secondly, if I would like any further assistance on those.
Very well, sir.
Yes.
Thank you.
Yes, thank you very much, Mr. Rawat.
Thank you, Commissioner. Our first witness today is the Honourable Mark Vanterpool. Before I continue with my questions of him, can I just introduce the legal representation this morning? We have Mr. Denniston Fraser present in the hearing room to represent the interests of Honourable Vanterpool, and attending remotely on behalf of the Attorney General and elected ministers is the Solicitor General Joanne Williams-Roberts. The representation for the remaining members of the House of Assembly who have participant status are not present this morning. Honourable Vanterpool, thank you for returning to give evidence today. You first appeared before the Commissioner on 14th of June when you made an affirmation. You are still bound by that. And so there's no need for you to take it again. You'll be familiar with some of the processes of the Commission, given that you have now given oral evidence a number of times. As is routine, we've prepared a hearing bundle, and you'll see the bundles there just to your left. There are 2 bundles in particular, the smaller ones that we might need to look through as we go through your evidence. Could I just ask you, as I have been doing of every witness pretty much, is just to remember to keep your voice up. I think it's always better to speak more loudly than not. You might want to draw the microphone a little closer to you because it doesn't actually amplify, it just records. And also something that you and I will both need to avoid is speaking over each other. But in that instance, if that happens, I will stop and I'll let you finish your answer. Now, your most recent appearance before the Commissioner was on the 30th of June. when you were asked questions about the project to extend the cruise ship pier at Wickham's Quay. You'll recall that I put to you a number of issues which arose from a report that had been issued by the Auditor General on the 31st of January 2013, and also from a report issued by the House of Assembly's Public Accounts Committee on 13th of June 2014. On the 13th of September 2021, the Commission sent to you what we have termed a warning letter. It's also historically known as a salmon letter, and its purpose is to set out potential criticisms that may be made of you and which arise from the evidence obtained by the Commission. Now, those criticisms, or those potential criticisms, concerned the port development project, and they were made of you in your former capacity as Minister of Communications and Works. I should emphasize that they do not constitute either the provisional or concluded views of the Commissioner. The purpose of such a letter is to ensure that you are fairly treated. You have, as requested, provided a written response to the warning letter, which you have signed and dated, and it also carries a statement of truth in the form that is set out in the Commissioner's protocol on the provision of written evidence. Can I thank you for the helpful way in which you have provided your written response, Honourable Vanterpool. But if we go to the last page of that response, please. Can you confirm that it is dated the 23rd of September 2021 and carries your signature?
I confirm.
Now, the warning letter itself is a confidential document. It is not one that has been published by the Commission, but obviously your written response is important. Can you confirm that you're content that that written response should form part of the evidence before the Commissioner?
Yes, I do.
Now, what I propose to do, particularly because in June we did go through some of the material in detail, is just to ask you some additional questions based around your written response. I will take you to some evidence that might assist you in answering the questions that I put to you. Now, as the Commissioner has just indicated, Cabinet minutes in relation to the port development project have just been received, and you will obviously have an opportunity, if appropriate, to raise that with the Commission in due course. But can I ask you this? Did you yourself retain any documents relating to the port development project when you left ministerial office?
You mean cabinet documents?
Or ministerial documents?
No, I don't have any of those in my possession. They were turned over to my, at the time, my private secretary, and she.
So you essentially, when you left ministerial office, which is, I think, an 8-year stint in ministerial office, wasn't it? You left all papers behind and did not keep any copies yourself. No,
I don't. I mean, you know, in the sense of truthfulness, I'm sure there may be documents scattered about that I don't have a recollection of any proper retention of such documents.
Thank you. Let's turn then to the first sort of element, if you like, of the criticism, which is that.
Sorry, just before I go off from that initial question you asked me, because I want to make sure. In terms of my evidence that I gave, I did try to get certain documents that I thought was relevant to my evidence, such as, you know, reports that dealt with the analysis and so on of the project, which I'll refer to when I speak to you today. Okay. And some of them are referred to in here. So right. Those are documents that I've tried to get access to since I've been subpoenaed.
I see. Well, can we break that down a little, please, Honourable Vanterpool? So 30th of June, you came and gave evidence. Yeah. If I could explain what we have collected. We obviously not just the Auditor General's report and the Public Accounts Committee's reports, but we have, and this has been provided to you, the minutes of the meetings with witnesses that the Public Accounts Committee held. We also have the interim report that the committee issued together with the dissenting report of the Honourable Marlon Penn. That's the sort of totality of the documents that we have. Were you able to secure additional material?
Yes, as I said before I came to this hearing, I tried to get, these are copies, for example, of, this is called the business case for Bridgeville Port Authority, dated October 2013.
Is that the BDO report?
Yes.
Right.
And this one is another BDO report dated January 2016. BVI Port Authority Cruise Pier and Park Project financial analysis. And they're free to have those also, Mr. Commissioner. And this one is a Tortola Pier Park financial memorandum that was done before that we have here.
What's the date of that?
This is May 2013.
All right. Okay, well, obviously, thank you for offering to provide them to us. They're documents that we haven't seen, so it may not be possible to ask any questions about them.
Yeah.
But let's try and get on and see where we are. The first element of the criticism, and you've split them up into individual criticisms in your written response, but the first element of it is that from November 2011, what we've called the Port Development Project was directed and controlled by yourself, knowingly and unlawfully to the exclusion of the statutory governing body and decision maker for the port, the BVI Port Authority and its boards. Now, if we give that some context, in November 2011, that you became Minister for Communication and Works, didn't you?
That is correct.
And at that time, following the election, the BVI Ports Authority, which had previously been under the, I think either the Premier's office or under the Minister of Finance, was transferred to your ministerial portfolio.
That is correct.
Was that a decision made in Cabinet, or was it a decision of the new Premier?
That was a decision made by the new Premier. We had not met in Cabinet yet. That was a portfolio that was given to me as a minister.
And when the Ports Authority came under your ministry, was the Port Development Project seen as a priority?
Yes, if I may, at the time, National Democratic Party manifesto indicated very clearly that this was a priority for the government. And if I may read from a short snippet from the manifesto, if I may. A National Democratic Party, this is page 14 of the NDP manifesto, a National Democratic Party government will be committed to developing and expanding the cruise ship pier so that we can attract more ships with a view of building a year-round cruise tourism sector. This will include proper and adequate shoreside facilities. The expansion will provide opportunities and partners with local businesses in offering attractive products and services will be vital to the access of this expansion. So yes, it was a very high priority of our government at the time.
You explain in your written response that you were briefed by Jeremiah Frett, who you identify as being then the Ports Development Liaison Officer in the Premier's office. Now, Mr. Frett was one of those who appeared in 2014 before the Public Accounts Committee, and he confirmed that he had shared information with you, including via email. Does that accord with your recollection?
Yes.
If you take the first of the smaller bundles, so bundle 1, please. And if you could turn up page 299, it's using the numbering that's in the middle of the page. this is part of the minute of the evidence that Mr. Frett gave before the Public Accounts Committee. And if you look at 49, he says that he was on the Ports Authority Board from 2008 to 2011. And then at 51, that he received a letter telling him that he would no longer represent the Ministry of Finance on the board, nor would he be having any dealings with port matters. So it seems to be that his evidence was that he was on the board as a representative of the Ministry of Finance. So can you just explain why it was your understanding that he was Ports Development Officer in the Premier's office?
I think from my evidence I gave, and you'll find that I'll stick to my evidence today very closely. I'm not going to. While I'm sure you will rely on a lot of other evidence, I'm going to stick to my evidence that I provided. And what I said here in my evidence is that Mr. Jeremiah Frett came to me from the Premier's office to introduce the project as he and that the ministry at the time had envisioned and had prepared it and presented the file to me, and I took the file from there as minister.
But Honourable Vanterpool, when you say Mr. Frett came to you from the Premier's office and from the ministry, which ministry are you speaking of? Are you speaking of the Premier's office or the Ministry of Finance?
As I recall, the Premier's office.
Thank you. Now, in your written response, what you say is that based on my knowledge gained from the cruise company, it became very obvious. It became obvious very early that the pier development project, as planned by the previous government and the Port Authority, was designed for smaller ships than the more modern ships operated by the cruise companies. Now, how did you gain that knowledge?
During the course of perhaps December and early January, and certainly confirmed in February in my visit to the FCCA, the Florida Caribbean Cruise Association office in Miami, at what they call a operations vice president's meeting that they have once monthly. During the course of that time, between December and that time, in conversations with most of the cruise lines that I met, with whom I met individually, on the phone, in various conversations, it was very clear from what they spoke to me at the time was that the cruise pair that we were pursuing at the time was much too small for the new class of ships they were developing and intended to deploy in the Caribbean, and that we needed to revisit the scope of what we were going to be developing. That was made even distinctly clearer when I visited the meeting at the in Florida at the time, and were told that unless we change course with what we were developing, the cruise companies would not be interested in calling because the smaller ships were not economical anymore to be used in the Caribbean, and they were all pursuing, and in fact, had already built the bigger ships to be deployed in the Caribbean.
Did your discussions at these meetings that you attended involve meetings with Disney?
Yes, Disney was part of it. The particular person, if I can recall, I met with the CEO of Disney at the time. I don't recall his name, but I also met with the operations chief, who indicated that they were pursuing a project with the BVI to accommodate their smaller ship, which carried about 2,000 passengers, but they were deploying some bigger ships and were looking for other Caribbean destinations to take those ships if the BVI couldn't. They particularly mentioned that they were negotiating with the Dominican Republic and I think St. Martin to deploy those ships, but BVI was going to be left out of the larger ships that they were deploying. And that was Disney, yes.
I mean, did that prompt you to ask how the BVI government had got to a point where in negotiations with Disney, they had a very evolved and detailed plan, which was the plan you inherited, which is I think 108, I think it was an 84-foot extension with 2 additional Maureen dolphins. How things had got to that point when, by, if you like, October 2011, when you assume office in November 2011, what you're hearing from cruise companies, including Disney, is actually the plan is not going to fit the modern ships.
Yeah, quite clearly. The discussions we had with Disney at the time indicated clearly that from their point of view, the government of the BVI felt that they weren't in a financial position to develop a bigger dock, and therefore Disney pursued smaller dock that could handle a smaller ship, where they would have a exclusive on one side of the dock for their smaller ship. However, they made it very clear that their preference would have been to be able to accommodate their bigger ships, and that's part of why we started pursuing not only their point of view, but we got that from every single carrier that we dealt with, which included Royal Caribbean, Carnival Cruise Lines, Norwegian Cruise Lines, Holland America, and I think there was one other that was there that represented, I don't remember the name of that company, but they all made that very clear and gave me details of their ships that they were intending to deploy and what the requirements were, the length and width and tonnage and so on that they were talking about. The tonnage difference was mostly a difference between the older, smaller ships of around 77,000 tons up to 170,000 tons for the bigger ships. Some are 160, some are 170. Those are some of the details that I got from the meetings that I went to there.
And can you help us with just sort of dates of those meetings? You've said that sort of, I think it ran from December 2011 into February 2012. Is that right?
Yeah, the main, there were discussions by phone and otherwise in December and in early January. I was invited to a meeting of the Florida Caribbean Cruise Association in February, I think specifically February 16th, 2012.
I'm sorry, Commissioner. Excuse me.
Solicitor General, can you see and hear us?
Yes, I can.
Good. Thank you. Thank you very much.
If you just turn up 362 in that bundle, please, page 362, please, Honourable Vanterpool.
362 or 360?
362.
362, thank you. Yes, I'm there.
This is part of the minute of the, I think it's Jean Crick, is it? Who's Creaky. Yes, is that the right way to pronounce
Creaky,
it?
yeah.
Creaky, thank you, Honourable Vanterpool.
We had a chat last time.
Yes, we did. Now, he was, I think, a long-standing employee of the Ports Authority. I think one of the longest-serving employees, and he served as deputy manager, or his position was deputy managing director. But between August and November 2012, Mr. Creaky was the acting managing director. If you look at 125, he refers to attending an FCCA convention. Do you see that?
Yes.
And at which Mr. Edward De Castro attended, but before his official appointment as chairman of the board, yourself and Mr. Claude Skelton-Klein, who was an advisor to you, and we'll come back to Mr. Skelton-Klein. But can you shed any light about that meeting? Was that one of the conventions at which you were meeting cruise ship companies?
Yes, that was a meeting. I don't remember the date of that meeting, but it was a meeting I attended. I met with several of the cruise companies, inviting them to propose to help us develop the cruise pair. I met with just about everyone at the time, and in fact, that's what those meetings are usually called for. It's not the regular, what we call the big sea trade meeting. It's a meeting where ministers and boards of all the Caribbean countries and other countries are invited to meet with officials of the cruise companies. And we met there, we met with Carnival, we met with Royal, we met with Disney, we met with Norwegian. Holland wasn't there, Holland America, but I think those are the main ones we met with at that meeting, yes.
And we've briefly mentioned what the proposal that you inherited. So, as we understand it from the documents that the Commission has received, as I said, it's an 84-foot deck extension with 2 additional mooring dolphins. So the effect is that the functionality of the deck is extended to 207 feet. And then there was an intent to build a welcome center. Or there was a plan to actually build a welcome center. So that was what you inherited, wasn't it?
Yes.
But was there at least an intent to develop the land side as well at some point in time? Were you aware of that?
Yes, and in the report there was discussion about the possibility of developing the land side in the future. And if you may allow me, my perspective of that very immediately was, and it came from the discussions out of those meetings with the cruise companies, that just having a welcome center and having what they call I forgot the word that they use now, very important. And there was the first impression you get when you land on a cruise ship of the city of Rotown was very poor. Old tents, people vending and so on. And they made it very clear that that wasn't the impression they wanted for their customers. So to just fix the welcome center and not develop the area that was, from my point of view, rather junky in looking, we decided to take a very urgent look at developing the land side also, and that's what we did.
Now, when you came into office and inherited this project, and inherited the plans that had been developed, were you aware that the Ports Authority Board had been able to put together a team, which included Mr. Fred, which had negotiated with Disney?
According to files, yes, I'm aware.
Sorry, I didn't catch your further.
According to the files that I got, yes, I'm aware that that project was a project. In fact, if you permit me, I discovered from the file that heads of agreement was signed with Disney on the 5th of October 2011 during the elections campaign, which personally I would consider to have been not the right thing to do on the eve of the election. But that was done, and that was the agreement that I met that was there with Disney to build a dock of the size that we spoke about.
Why do you say personally it was not something that it was something that made you feel uncomfortable?
Well, one government signing a document of that nature and for such an important development 30 days before elections would mean that that government would be effectively making the next government adhere to such an agreement, and I didn't think that was the right thing at that time.
But nonetheless, I think you agree that because the team that negotiated with Disney would not have involved, if you like, politicians. It involved what I think many elected.
But may I say that it was signed by the Premier?
No,
so I don't against can't say that it wasn't involving politicians. No, if I may.
Well, no, but I mean, I can take you to Mr. Frett's evidence if you wish.
I don't wish to.
But
I think I want to make it very clear that my testimony here today is to give you a full account of what I did to move this project forward. I am not going to go back to who said, who did not say, and what suggested. That's for you to consider. I'm sure you will in your considerations. But I'm here to give evidence of what I did to execute the project, if I may.
I think Mr. Rowett's point is that that agreement signed just before the election was negotiated by public officers, signed by the Premier. I understand that. Obviously, it had to be, but it was negotiated by public officers.
And that is fine. However, with the new government's policy, Mr. Commissioner, if you allow me to say, I felt we want, what is the word? We want committed. We didn't have to be committed to carry out the same project as we felt we wanted to carry out a different scope of project. And therefore, that agreement, which was non-binding, was eventually canceled, as I'm sure you're aware, from the evidence that was given before. But
well, you've indicated the policy of the new government, which was the policy set out in the manifesto.
Yes, to develop a pair that could accommodate the modern day ships.
Yes.
Yes.
Were you aware of the expertise that there was on the board itself?
I would say very clearly that if the expertise on the board was paying attention, they would have known that the cruise ships coming to the Caribbean at this time were not the ones that were building a dock for. As simple as that, I would say. So I would not challenge the expertise. I would not investigate it. But I would say that very clearly from the evidence I got from the cruise companies, whatever they were going to build would not have lasted and sufficed the country's growth in cruise tourism, for which I felt I had just become responsible.
I think, Honourable Vanterpool, it's a drawing that line between the elected official and the public officer, isn't it? Because the point I'm trying to explore with you is, it may have been the policy of your predecessor government in 2011 to build a smaller dock, or to build a dock or to spend a certain amount of money. You came into office, and as you've explained to the Commissioner, your manifesto had a different policy initiative. When questions are directed towards the expertise that public officers had in delivering policy objectives. So in this case, if we take the policy objective of the previous government, which had resulted in a heads of understanding, leave aside the timing of the signing of that. But the point is that within the BVI Ports Authority, there had been a negotiating team capable of negotiating with the cruise ship line, specifically Disney. You'd accept that, wouldn't you?
Repeat that, because I want to make sure I don't accept anything that you're saying that I'm not in agreement with. I may accept but not agree with. So let's hear what you're saying.
Well, sometimes acceptance
can have a wrong connotation, yeah.
No, acceptance can be construed as agreement.
Yeah,
so let's make sure what you agree or accept.
Exactly.
Go to 302 in the bundle, please.
Yes.
If you look at 70, we're looking at minutes of the evidence of Mr. Frett. So he speaks then about his involvement in the, let's call it the predecessor project. So he speaks there to details with Disney. Royal Caribbean Cruise Line had been one of the first companies they'd met with. He said that negotiations had been taken to a higher level and things had gotten a bit tedious and heated because the board had conducted the meetings themselves without having a consultant to represent them. He said, he concludes that there had been several persons on the board who had expertise, including the chairman of the board, deputy chairman of the board, financial comptroller rather, Mr. Paul Webster representing O'Neill and Webster and others. And then if you go to 321 in the bundle, In response to questions, Mr. Frett then said that the board had been well advanced because the project had been studied and overstudied. He further stated the board felt that there was no need to go and spend any more money. He indicated that they had felt competent enough to conduct document reviews and noted that most of the time the information is already available. The Auditor General then, who was the advisor to the Public Accounts Committee, then stated that the decision had basically been made by the board. Mr. Frett, over the next page, 322, responded in the affirmative, stated there had been an effort by the team which had consisted of the chairman, deputy chairman, managing director himself, Mr. Franklin Waters, who was the head of the Ports Authority's Finance Committee, explained the team would always go back to the board, provide updates on what was taking place. When asked, then at 236, he confirmed that the team, the negotiating, had gone back to the board for ratification, and that they'd provided the minister. And at that time, they were obviously under a different ministry, but they provided the minister with updates. If you go back to 95 in the bundle.
Mr. Chairman, Mrs. Commissioner, if I may.
No, pause out.
No, but the point I'm going to make is going to suggest that we don't need to go through all those, because I'm going to make a very clear point. I am not challenging expertise of the board or public servants. I'm just saying very clearly, the government that I was involved with at the time directed that this project be changed in scope. It doesn't matter who was the experts before, whatever they were doing. In our view, what they were about to do was not the right thing that suited the territory, and the policy of the new government that I was involved in decided to change course. Whatever those experts may have said, they may have been right about it at the time, but I am letting you know that from my point of view in the investigations that we were doing at the time, all what they have said and all what they were doing, to me as minister, were futile in terms of satisfying the needs of the territory of the time for cruise tourism, as was clearly stated to me by the group of users that will use the facility. So I want to make it clear that whatever they've said before, I'm not going back to all those, I'm not answering any questions in them. I'm very clearly stating that, as I stated in my statement that you asked me to respond in, I took a different view and presented it to the government at the time in the cabinet, and that is the direction we decided to go. Well, I am not going to continue arguing or saying whether they're right or wrong. You make your conclusions in that, I may say, but I am letting you know what I gave you evidence on and what direction we felt we should go. I just hope that you respect that from me.
I think
you want to be clear on that.
Commissioner very much has that point now.
Yes,
but
thank you.
The purpose of the questions was to a different thing. You said that you inherited. You spoke to Mr. Frett. You said that you inherited a file that you looked through. Let's put the questions that way. The reason I took you to the evidence because you drew a distinction between accepting and agreeing with something. So the point is this: when you took on the project, when you read the file, were you aware that the Ports Authority Board had put together a negotiating team that had negotiated with Disney?
Yes, I answered that. I was aware.
Yes. Were you aware of the expertise in terms of who was on the board? Were you aware of the expertise that board offered?
As I said before, the expertise is a matter of opinion. In my view, when I became minister, I wanted to consult in a different way in terms of where the project was going. The expertise at the time had been correct, but I'm not aware of what was necessarily the qualification of that expertise. But I'm saying that very quickly I drew the conclusion as minister, in the interest of the public, that project based on what was proposed was not the right project at the time. And that was a new policy of the government, and I took it in that direction.
Were you aware that the BVI Ports Authority Board had access to legal and technical support?
I'm sure they would have. I don't know. I wasn't specifically aware, but I'm sure they would have.
Were you aware that they had been able to take the project, which was one that you no longer felt was valid, but they had actually been able to take that project to a point where they were ready to go to tender?
I'm not aware of all that. Perhaps it was in the file, yes. In fact, I believe they might have tendered a project already, as far as I recall.
Because you say in your written response, this is at page 3, that you had begun to gather, you say we had immediately began to gather information and invite proposals for a suitable pier expansion and landside development. Our intention was to develop the scope of the project, receive proposals, establish a heads of understanding, and then present the project as proposed to the BVI Ports Authority and the public for consultation and suggestions. The question is this, that given the experience that the recent experience that the board had, and that the file would have shown you that they had been able to gather a negotiating team, that they had expertise on the board, that they had access to legal and technical support, that they'd been able to take a project to a point where it could be tendered. There was no reason, was there, to do what you did do, which is to exclude the board from the process entirely once you became minister?
That is not my account of what I gave, if I can respectfully say. I will reiterate, the course that the previous board and government was taking was, in my view and the view of the government at the time, not the course that we were prepared to go with. We scrapped that course and began to gather information, as I said in my statement there. We immediately began to gather information and invite proposals for suitable pier expansion and landside development. Our intention was to develop the scope of the project, receive proposal, establish a heads of understanding, then present the project as proposed to the BVI Port Authority and the public for consultation. If you're suggesting that I was incorrect to stop the project at a point and go to a project that we envisioned would be the correct project, I would say that I think I did the right thing, and therefore I was not going to continue with the project as envisioned and with the project as stated it was. And therefore, that's the position we took. And I don't know if you want me to say, this is my evidence. If you want to have a different conclusion, surely it's up to you, but this is my evidence.
But let's just focus on I think the real thrust of the question. What had happened was the previous administration had a policy to increase the size of the pier and to have a welcome centre. That was their policy. And the Ports Authority Board developed that, negotiated it, and by the time that you came to your administration, it had signed heads of agreement with Disney, and they were ready to go to tender. Your government came in and changed the policy. The policy changed from having a pier of a particular size to cater for particular ships to a longer pier, something that would in effect last longer because the ships were going to increase in size, and also to develop the land side a lot more, to have more than a welcome centre. Change of policy, that's absolutely fine. But the previous administration's policy had been developed and negotiated by the Ports Authority Board, because that was their job. When you came in, and that's the paragraph that we've been referred to in your response, we, and by we, I assume you either meant I or at least the ministry, immediately began to gather information and invite proposals for a suitable pier expansion and landside development. Our intention, that's your intention, was to develop the scope of the project, receive proposals, establish a heads of understanding, then present the project as proposed to the Ports Authority and the public for consultation and suggestions. That's the point, isn't it? That it wasn't simply your policy, you were going to run with the policy.
I think if I may, Commissioner, to be fairly explicit, the board that we met was going in one direction, along with the minister who was then responsible for the project. we came into office, and as minister, we took the opportunity to halt the project as it was, establish a different scope, investigate how we would go forward with the project, invite proposals, and then take it forward. The board that I met there was not, in my view, prepared to go along with that kind of project. But we wanted to get the right scope and present it to the board for their execution and approval of the project, which we did in due course in July of 2012. But this is the position that we took. And I took that position under my authority as minister of the Port Authority. I'm answering you, Commissioner. I took that position from that point of view. And the evidence will show that that's what we did. We may have changed course as to how we did it in the ensuing 6 months, but that is what we did. And I just want to make that very clear as a position.
But you can see can you see the difference between an administration having a policy, as the old administration and your new administration had different policies, but you had a policy, and in the one circumstance, the Port Authority board running with that policy, negotiating the contracts and so on, and presenting the project, which was then signed off. And in your case, you had the policy, but the Port Authority board did not run with the policy. They weren't allowed to run with the policy. You ran with the policy. It was your intention, it says here, to develop the proposal and present it to the Port Authority board. There is a difference there in approach. I know you say you had power to do it and it was the right thing and a lawful thing, but it was a difference in approach.
And Commissioner, yes, but you must consider the circumstances to adopt such an approach. And that here was a Port Authority board 30 days before going in one direction. A new administration takes over and immediately wants to change that direction. And therefore, while there was no disrespect to the Port Authority board, because we did have discussions with individuals of Port Authority board until it was time to present what we considered to be the scope of project we wanted to pursue. But the circumstances were different. They were already going in a direction that we think wasn't right. We had to put a halt to it as minister and as a ministry who, in consultation with the other members of the government, decided this is the policy we want. These are the things which we, in terms of scope, that we want to pursue. And while one may think that we didn't go and have the board take it over, at a point when we considered that we would, we decided to take the scope at a point. Now, that's a judgment that one may make, but that's a judgment that we made at the time to move it in that way until we were satisfied that we could present it to the port as what we want to pursue and let the port take it from there, which is what we did.
But weren't the Port Authority board before your administration pursuing the policy of the previous administration? They were then presented, or they would have been presented if they'd been given a chance, with a new policy.
And they were, at the time that I felt that it was needed to present it to them, and which we did.
Thank you.
Honourable Vanterpool, can I just explain? I mean, the purpose of my questions is to ensure that you are treated fairly. Now, I recognise you have told the Commissioner more than once that your evidence is your evidence and that he can draw whatever conclusions he wishes from any other evidence. And you're just going to stick to your evidence. But what I am trying to ensure is that I draw to your attention relevant matters and give you an opportunity to respond today, so that we can ensure that you are treated fairly. And there is, on the evidence,
but I'm not sure if I may understand what you consider to be treated fairly for me. As far as I'm concerned, as I said, I have given you a recollection of this project as best I could. I'm not sure what you're talking about being treated fairly. All the things that you're talking about, I may say, may be relevant, which I have considered, but I have given you the evidence as to what I did to pursue the project. And I do hope that you are respectful enough to understand that whether it was the correct direction or not, I'm giving you the evidence of how the project was pursued.
But the potential criticism doesn't go to whether to the policy decision. It is about how the project was pursued.
And I've given evidence of how it was pursued, not just the policy.
Well, can I,
if you don't mind, and the 9 criticisms that you asked me to respond to.
Well, if your answer to my questions is just to say to the Commissioner that you have nothing further to add, or you don't wish to comment on something, or you don't wish to respond to something, then you can give that answer.
That is what I'm saying. That is precisely what I'm saying, Mr. Commissioner. Without any disrespect to you,
no,
I have totally considered all the evidence that you presented to me, and I've given you my responses, and I wish that you would accept my response and look at what I said. Like I said very clearly, I've done nothing, in my view, unlawfully. I've given evidence that this project was done in a public way. I went to various public meetings on this project between January and July and thereafter. And this is where it pursued. The project began where we invited proposals at the beginning. We felt later on, after the protocols of financial management was signed in April or March of 2012, that we should change course in how we invited proposals, or how we bid the project. The project went out to bid later. We made a selection later on in the year, and we pursued that. The selection turned out that what was considered to be needed to finalize the project with that group were not satisfied, and we took a different angle. The cabinet decided to have the project pursued entirely by the port and built by the port at the time. That is very simple how that project went forward. That is my evidence. I am not here to discredit any other evidence, and I am not here to add any more evidence. I've given you my evidence as best I could in the statements I gave you.
Well, let me prevail on your good nature a little bit more.
Okay.
Let's see whether you can at least try and give you an opportunity to respond to some details. Now, in your written response, you've told the Commissioner that you had several meetings with the Managing Director. If you turn up page 496 in the bundle.
I'm not going to refute the Managing Director's statement there. I read it. I have had meetings with him. The Managing Director signed an agreement with an environmental specialist we hired to do an environmental study with a new scope. The Managing Director's testimony, I'm not going to refute it, but that is, I know the meetings that I've had in my office and elsewhere with him, and I'm not going to go back to refuting. I'm not going to go in that direction. This is my testimony. I met with the Managing Director. You may accept it or not accept it, but I am not going to go back and forth with that, Mr. Commissioner.
So you don't wish to take an opportunity to respond to the evidence that the Managing Director, which was Vincent O'Neill, gave in 2018 to the Public Accounts Committee, that said he had had one meeting at the ports with the current Minister of Communication and Works, and that was when he came to a board meeting.
I gave my evidence in here. That this is my position. That is his position. I gave you my evidence that I met with him several times, including his signature in April on a document requiring Dr. Cassandra O'Neill to conduct an environmental study on the new scope of the project. My evidence is there.
All right. You refer to that the ministry's representative on the board had responsibility to praise the ministry of various decisions at the board level. Is that the permanent secretary who will be an ex officio member?
At different times, it was perhaps different persons. I recall when I became minister, it was a deputy permanent secretary who was sitting on the board.
Well, Arlene Smith-Thompson, who was your permanent secretary, confirmed that she was the ex officio representative on the board. But her evidence could lead the Commissioner to draw the inference that as permanent secretary, she was sidelined.
Mr. Commissioner, there is no way anybody could be sidelined in the project in my ministry that was front and center. And that was not so, is my evidence.
Well, you've gone a bit further than your written response now,
Well,
Mr. Vanterpool. You want me to take you to her evidence so that you can...
No, I will not. I'm saying that all officers in my ministry were involved in the project.
The chairman of the BVI Ports Authority, Gregory Adams, said that he had received no instructions in writing in relation to the port development project. He did say that Lord Skelton-Klein was fully involved in that project. Did you give instructions in writing to the chairman of the then chairman of the Ports Authority?
No, I did not.
Vincent O'Neill, whose evidence that we were looking at, said he never received instructions in writing. That was his evidence to the Public Accounts Committee. Did you ever give instructions to Mr. O'Neill in writing?
I said, I met with the managing directors many times. We were pursuing the project to the point where he was involved in several aspects of it. And at the right time, and we took the project to the board. The person who was consulting to me went to the board, met to the board. My permanent secretary would have known what was happening with the project and should have informed the board. And at the right time, I myself went to the board and gave them a full account in July of what we were pursuing. And at that point, the board passed a resolution to go in the direction that we're pursuing. That is my evidence.
An inference that can be drawn from the evidence that the answers that those on the board gave to the Public Accounts Committee was that they were placed in a position where they had nothing to do other than sign off the resolution.
You may accept whatever inferences you want. I've given my evidence that I had informed the board properly at many times, the managing director, and the board was informed as to what was happening. Whatever inferences were taken otherwise, I am not going to refute, but I'm telling you what my evidence is.
But nothing in writing? No instructions in writing?
Not that no direct instructions right now that I can recall, Mr. Commissioner, if I may, but my evidence is that my appearance at the board in person to give specific directions, in my view, sufficed even more than something in writing. I gave explanations. I gave the board opportunity to question me in that meeting, if you check the board minutes of that meeting. And that was clear instructions from my point of view, according to the law, where the minister can direct the board. It may say in writing in the law, but it was very clear at the board meeting of all board members what the minister wanted by my evidence that I took there and by my direction that I asked. Those were the clear directions in the board meeting. Minutes were taken of my directions. That should suffice more than even something in writing from me to the board. That is my, it may not be your conclusion, Mr. Commissioner, but that is my
Mr. Rowett's initial question was,
if I may.
Any instructions in writing? The answer is no, but
not. I wouldn't say none, but not I can recall.
Yes, thank you.
And following up on that, when you were not, if you like, appraising the board of developments directly, Mr. Skelton-Klein was doing it on your behalf.
Yes, there were times when I think I can recall one or two meetings when it was done that way. Yes, Mr.
I won't take you to it, given your position on others' evidence, but for your note, Commissioner, it's in the first bundle at 230. But one of the points that was made by a member of the board, Naomi Turnbull, to the Public Accounts Committee was that Mr. Skelton-Klein went to the board with detailed plans and diagrams and took them and put them in front of the board. So when he was doing that sort of detail, when he was involving himself in this project, that was at your direction?
Yes.
I'm sorry to interrupt again. I'm looking at your written evidence because you say that this really is it. What that paragraph does is it says that board members were informed of the development.
Sorry, what paragraph here?
It's the big paragraph on page 3.
Page 3, okay, good.
The second paragraph.
Yes,
You say that board members were informed of the development at one meeting at the 26th of January. They were briefed, it says, on the 8th of March. The report informed the members again. You attended a board meeting on the 3rd of May to provide information to the members about the selected proposal. So this was you informing them of what was going to happen.
yes, and this is from the Auditor General's report.
Yes.
The exact words are from the Auditor General's report, but it is what happened.
But you as the minister were informing the board as to what was going to happen.
Yes, Mr. Commissioner.
Yes, thank you.
The Commissioner's made the point to you that obviously your reliance on certain elements of the Ports Authorities Act or certain sections is something that we will have to return to as under any legal submissions. So let's move on to the second criticism that you deal with.
Can I just ask one question, which I think is a proper question? We'll deal with the law with your legal representatives. But you rely most heavily, I think, on Section 19. You rely, I know that you refer to other sections in the Act as well, but mainly Section 19. And you say that this gave you the powers to do what you did, and you explained what you did in your written evidence and also in your oral evidence. Did anyone advise you as to the effect of Section 19 at the time?
Mr. Commissioner, I can't recall specifically, but clearly from my point of view, the spirit of the Act, when it refers to the minister's authority when it comes to port development activities, for me was very clear. Any capital project that the port would undertake had to be approved by the minister. And in our view, at the time, it was the minister and cabinet, which is how we operated. Therefore, that indicated to me that any capital development projects could come under the purview of the minister. And it is not only in that number 19 that as I pointed out in other areas. I wanted to point out the other areas to show that the minister in that act had several aspects of authority in dealing with the port operations and the port's development projects. And that's what I wanted to point out.
No, I understand that. And as I say, that as a matter of law would be a matter for your legal representatives.
It is not only a matter of law, Mr. Commissioner, for my legal representative. I'm the witness.
No,
So it's a matter of law for me also.
No. Two separate things.
Yes.
Firstly, as a matter of law, we'll hear submissions on the law.
Yes.
But where you can give evidence is how you understood the law to be, which you've done.
Yes.
And also whether you sought or were given any advice, to which the answer is no. This was your understanding from reading the Act.
I said I don't recall having any specific. I think what you're asking, any specific legal advice.
Yes. No,
I don't recall having that.
No, but it's quite proper for you to give evidence as to what you understood the law to be and how you acted.
Yeah.
What the law is, we'll wait for Mr. Fraser.
I accept that. I accept that, Mr. Commissioner.
Honourable Vanterpool, you just told the Commissioner that you can't recall receiving any legal advice. You had, I think, been out of government and I think out of the House of Assembly for 4 years before returning.
Sabbatical.
Sabbatical.
Yes.
On return, did you actually seek any advice about your powers under the Ports Authority Act?
My answer will be no. I don't recall any specific. I was aware of the Act. I made myself familiar with the act when I got the portfolio. And that is how I operated based on what the act.
On your understanding of what the act allowed you to do as minister?
Yes, yes.
Okay, let's turn to page 4 of your written response, please, Honourable Vanterpool. What the criticism goes to is that there was a substantial change in project scope was made at the direction of Honourable Mark Vanterpool and without prior cabinet decision. Now, this is the project that developed under your ministry, which was, as you've explained, a much bigger expansion of the pier than envisaged under the previous administration. Now, you point again to section 19, but and the powers that gives you as a minister. But was it your understanding of what you could do as a minister with the Ports Authority under your ministerial portfolio? Was it your understanding that you could expand the scope of what the port was going to do, what the authority was going to do, without cabinet's agreement?
No, not at all. That was not my understanding.
See, so you didn't see section 19 as giving you the power to act, to change the scope?
Yeah, well, that might have been the law, but we always operated, if I may, as a government. And I don't think it's just my government at the time, but other governments always operated as minister in cabinet. That's the way I understood it. So if we had a direction the minister wanted to go on such a major project, we needed the cabinet's approval and the cabinet's involvement. That's the way I understood it. And that's the way we operated.
I understand that, perfectly sensible. But as my understanding of your view of section 19 is that it gave you as minister the power to increase the scope of the project. You may well have gone to cabinet to make sure that that was fine, but you didn't have to under section 19. I'm sorry, that's my understanding of your view of your powers.
Yeah, that is not a correct understanding. It's probably legal, but I said my understanding, I just stated it. My understanding was that I was operating in terms of carrying out this change in the scope as minister in cabinet. I had to get cabinet's approval, in my view, to change the scope.
Your view was that, well, your view was that to change the scope under section 19, I think, but to change the scope, you could only do that with cabinet approval.
I don't know if I could only, but I'm saying, Mr. Commissioner, that was the way we operated.
I know, Mr. Vanterpool, and I'm sorry to press this point.
It's okay.
The first thing is your powers. What did you think your powers were? My understanding was that you thought your powers under section 19 enabled you to do this. The powers in section 19, the powers in the minister, full stop. You may well have wanted, for all sorts of reasons, including comfort, to take a project, the huge change in the project to cabinet for them to give it a nod. But your powers, if they were under section 19, were your powers, not powers in cabinet.
Thank you, Mr. Commissioner. Let me just explain it a little differently, if I may. The initial stage of how we operated and how I operated was to gather the information, gather the needs, gather the scope. And my understanding is that as minister, I could not change the scope and direct a project like that as minister only. That was not my authority. I could not do that. One, I would need the cabinet's approval and the Minister of Finance approval to fund the different project, especially. And therefore, there is no way of my understanding that I could have done this without cabinet. That's all I'm saying in my witness. I could not have done it without cabinet. And all along the way, all members of cabinet were informed, were involved in the hearings and in the presentations. And in the end, on July 11th, when the board resolution came to cabinet, cabinet authorized me to move forward with the project. I did not go forward with the project as a minister, as number 2 is indicating. I clearly refuted that. my evidence.
And what you say, so we can be clear, is that Cabinet authorised the change of scope in the project in February 2012. So can I check with you how that happened? So as we understand the process, a ministry would put together a memorandum, which the minister then takes to Cabinet. Cabinet makes a decision and action is then taken. So in this case, having done the investigations and sought the information that you had, would a paper have been put together for you to present to Cabinet to say, I would like authority to now take the project in this direction?
Yes, and this is where, Mr. Commissioner, I asked to see Cabinet papers to refresh my memory as to when it all happened. So I would change what I said here in the context that a report was given to Cabinet in February, but Cabinet authorized the project in July 11, 2012. When I was writing this, I didn't have any evidence of it. I was able to get as to when this happened. So, Mr. Commissioner, I could change that from what I said. Cabinet authorized this change. Cabinet was made aware of the request to change in February of 2012. However, Cabinet authorized this change of scope in July 11th of 2012, following the board resolution that was presented to Cabinet. That is the evidence I would like to offer, Mr. Commissioner.
See, what is recorded in the Public Accounts Committee report? I'm going to quote it. It's at page 9 in the bundle, Commissioner. But at paragraph 33A, the Public Accounts Committee records that on the 26th of January 2012, the minister attended a board meeting of the authority and informed the board that he had decided a new direction for the cruise ship port development project. The minister also advised members that he'd already received 2 proposals for the upland development and was expecting a 3rd. So doesn't that suggest that you had rather moved quite some distance along the way, even before you took the matter to Cabinet?
Precisely. I said to you that during the months of December, January, February, and therefore we were exploring the project and getting proposals. That is what I reported to the report. That is what I reported to the Cabinet. In fact, the Cabinet heard the proposals themselves, if I may say. So yes, that is the evidence that I presented, and you are correct.
I see. Okay. But and what Cabinet there? So your evidence now is that there was a report presented to Cabinet in February 2012. Who prepared that report?
No, I said I informed Cabinet of where we were. That Cabinet meeting, basically, as I recall, was a report that I gave following my meeting at the Florida Caribbean Cruise Association in February 16th, 2012. And I came back and reported to Cabinet what direction I think we should go based on what was presented to me at that meeting. And that's what the Cabinet minutes reflect. It wasn't a resolution or a written proposal to Cabinet. It was a report to the Cabinet of what I had gathered and where we think we should be going.
A more accurate way of putting it is that on the 16th of February 2012, your recollection is that you made a verbal report to Cabinet.
That would have been, I was in Florida on the 16th, so that would have been the following week, I believe. It was either the 20th or the 23rd, I can't recall the exact date, but it was in that context, yes, and within that time frame.
But Cabinet did not make a decision until July 2012.
That is correct.
You say that the board was expected to be appraised of the change in scope of the project by my permanent secretary. Who expected the board to be appraised by your permanent secretary?
Well, I think it's fair to say that as was indicated and as you just pointed out, the board was appraised in January 26th, according to the evidence that you've just reported there. And the understanding is that there's a monthly board meeting, and whoever is representing the ministry at that board meeting would have praised the ministry of the direction we were going. And that's what I'm indicating there, Mr. Commissioner.
Now what you say is, as minister, I praise the board of the full scope of the project in a board meeting dated 8th of October 2013. The board approved a resolution to move forward accordingly. What happened in October 2013 was that, according to the Public Accounts Committee, you attended a meeting of the board and informed them that the arrangement with TPP, which you had been negotiating with Mr. Skelton-Klein, had ultimately been unsuccessful, and also that the tender process overseen by the Ministry of Finance had not been unsuccessful, and now the matter was coming back to the board.
That is correct. That's
what happened in October 2013, wasn't it?
Yes, as I recall.
So it wasn't a. So what you're saying, where you say I praise the board of the full scope of the project in a board meeting, it effectively is that almost 2 years after you assumed office was when the board got to know the full scope of the project.
That is not correct. Let us go through the period of time that brought us to that point, if I may. My evidence that I gave, my evidence is clear there. The project was, as I said, between December and July, we did research, we had presentations. We had 3 groups presented. The government decided to have further negotiations with 1 group. That process was discontinued in, I don't recall, could have been July. And a broader tender process was pursued in 2012. And I think it was October or some point there in October when a negotiation committee was selected to review the proposals made by 2 of the companies who presented who bid on the project at that time in the second round of bidding. There were TPP and Royal Caribbean. That negotiation team came back to the cabinet through the procurement process and recommended that we select Total, the TPP group. We met the TPP group, presented their proposals, and during that time, an agreement was made based on certain conditions precedent. If I recall, there were 9 conditions that they had to meet before you would make any final arrangements with them. In sometime in the following year, I don't remember the exact date, they failed to meet, if I recall, 2 or 3 of the conditions precedent. One of those was very important to us, and that was whether they could finance the project as they had proposed. And it was at that time that the Minister of Finance gave them notice of discontinuation. And that's how we got to, I believe, October 2013 is what I may say as my evidence, as I recall.
But be clear about this, please. I mean, and I've taken you to a date or 2, and you've given others where you say there was meetings with the board, but it's just that, and this is your words in your written response. As minister, I praise the board of the full scope of the project in a board meeting dated October 8th, 2013, end quote. So on your words, it appears that it wasn't until October 2013 that the board got to hear the full scope of the project.
I think you know, if it's I just stated to you how we got to that meeting, Mr. Commissioner, and through that process, the board was involved. There were board meetings before that. The chairman of the board discussed the project. If you go to the minutes of the board between July of 2013 12 and October of 2013, you would see lots of minutes regarding this project that were dealt with by the board. So I would suggest that you get the minutes of the Port Authority and look at how the board was involved during all that time while we were in this process.
What the commissioner has is minutes of answers that members of the board gave to the public.
I suggest we get minutes of the board meetings during that time. What members said in these discussions, I would not be willing to attest to. I would like you to go to the board minutes between that period of time and see how we got to October 2013.
But what they did attest to was that during the time that you were leading the project with Mr. Skelton Klein, so November 2011 to July 2012, they were nothing more, in effect, than a rubber stamping body. Their only job was to sign up to resolutions that were put before them. They had no other involvement in the project at all.
That may be the evidence, but they were given opportunities to, from my point of view, whenever I went to meetings or when my representative went to meetings, to give suggestions, ask questions. There were public meetings which they attended. That information from the public meetings was shared with them. So it behooves me to understand that they weren't aware. They may not have been involved in the full research as they were in how to handle the previous project. But after we turned it over to them, the port took control of the project and went forward with it. That is my evidence that I have. I'm sorry, but that is what I have to offer.
Thank you, Honourable Vanterpool. Commissioner, if I could ask now for a short break for the stenographer.
Yes, as you know, we have a stenographer and he needs a break after about an hour. So we'll have a 5-minute break now. Thank you.
Thank you.
Mr. Albert, we're ready to resume. Thank you.
Thank you, Commissioner. Mr. Honourable Vanterpool, can I take you please to just the next criticism, which is at your page 4 of your written response. And it is that you retained Mr. Claude Skelton-Klein as a consultant for the purpose of liaising with the Port Authority and advising on port-related matters without a transparent selection process and without evidence of Mr. Skelton-Klein having any relevant experience and without him, in fact, having any relevant experience. And you've said this, at the time, it was my considered view that it was the minister's discretion to appoint consultants under the budgeted amount allocated to the ministry. At that time, it is my knowledge that consultants to ministers were not posts that would normally be advertised. I appointed a consultant who would liaise with experts and focus on the urgent need to move the project to the development stage, after which it would be turned over to the BVI PA. I was not seeking a consultant who was an expert on port matters, but rather one who would be the chief liaison between myself, the Ports Authority experts and stakeholders. Now, on 30th of June, when you gave evidence, I took you in some detail to then. You gave your answers about Mr. Skelton-Klein's appointment to the Commissioner. So I don't want to go over the ground again. Could I just ask you some questions, however? You say in your response, it was my considered view that it was the minister's discretion to appoint consultants. What did you take into account to reach this considered view about the appointment of consultants?
I'm not sure what your question is. I apologize, but can you repeat that question?
Yes, it's just
let me understand it.
The first sentence of your response goes to not just Mr. Skelton-Klein, but the appointment of consultants. And you say that there is a budgeted amount allocated to a ministry that it can use to appoint consultants.
Yes.
Now, would it be right to say it like this, that it was, it's at the discretion of the minister whether a consultant gets appointed or not?
Yes, that was my view.
Right, but this was the purpose of the question. You say not only do you say it was not only your view, but it was your considered view. And it was the word considered that my question was directed to. So what factors did you take into account when considering your view?
I considered that I needed a person who would be focused on, as I said in my notes here, focused on who was not an expert, rather one who would be a liaison between myself, the Port Authority expert and stakeholders, and would be focused on trying to execute what we wanted to do, and that was what I considered.
Right. I mean, the question was not about Mr. Skelton-Klein. It was about your considered view as to the minister's discretion to appoint consultants.
Yes.
Well, how did you come to that considered view that a minister had a discretion to appoint consultants?
I don't know what would be your technical understanding of considered view, but it was, in my opinion, my discretion, and that's the way I saw it, that as a minister coming in to take over the portfolios that I wanted to do, and I needed someone to work with me to carry out some of my missions, such as this one, that's the view I took to have a consultant to do it, if I may say.
Now, you obviously had more than one mission as minister.
Sure.
Did you appoint other consultants?
In due course, yes.
During that administration?
Yes, I did.
How many other consultants did you appoint?
I appointed a consultant to deal with energy and renewable energy. Those are the two main ones that I can recall. Yeah, I don't recall any, but those are the two main.
And presumably, because you'd appointed Mr. Skelton-Klein from a budget allocation within the ministry, he would have had a contract with the ministry.
Yes.
And is that the sort of contract that's signed by a permanent secretary, or is it signed by you as the minister?
I can't recall, but I think that as minister, I signed it at least as one signature.
And he was, I think, your first consultant. There may have been another, there was another one later on in time. Okay. But how was he expected to report?
He was expected to report to the minister. I'm not sure what your question is, but if that's what you're asking, yes, he was reporting to the minister.
Just directly to the minister?
Yes.
And was he expected to report by producing a written report, or did you just expect verbal updates?
There were various updates. Some were written, some were verbal.
But what was the expectation?
Written and verbal.
Let's go on then to criticism number 4, please, at page 5 of your written response, which is that despite the change in scope and the scale of project, there was no suitable project appraisal, no comprehensive planning, no detailed development proposal, no needs assessment, no cost benefit analysis, and no cost estimate. And you explained that the initial phase of the project was a mission to gather information to further develop the project scope. So let's pause there. Who embarked on that mission to gather information?
My consultant and myself.
Right, so the two of you worked in tandem?
Yes, right? Along with the ministry persons, and we had discussions, like I said earlier, with members of the port, including the managing director of the port. Several discussions.
But certainly Mr. Skelton was leading on that project.
Yes.
And in discussions, you say, with people in the ministry, who would those have been with?
My permanent secretary, as I recall, and primarily my permanent secretary.
You go on then that you don't accept that comprehensive planning was not done because you point to a business case being provided by BDO. Is that one of the documents that you've produced today?
Yes.
Remind us of the date of the BDO document.
That would have been October 2013.
Right. Now we know that that October 2013 was when the Port Authority took, or the project was handed to the Port Authority. Was the BDO report prepared for the meeting that occurred on the 8th of October 2013?
No.
What was it prepared for?
No, well, let me bring you back, if I may, in understanding how this project was intended to be executed early on, and would give you an understanding that these appraisals and these proposals were done, were expected and proposed to be done, and in fact, information was submitted through the public-private partnership arrangement. Let me explain. Under the public-private partnership arrangement, the government was not undertaking any financial aspects of the development, or the government was not undertaking any capital responsibility for the project. The government's involvement was to provide the land for the development in the public-private partnership arrangement, and the developers were to raise the money, develop the project, and then the government would engage in a fee sharing agreement over a period of time. After that period of time, the land and the project as it was developed would be handed back to the government. That was the proposal, and that is why I say it wasn't until the government took over the project, the Port Authority took over the project, is when we asked and we got a development business case to be done by BDO. Prior to that, a business case was presented in, I think it was in, I don't know if I have it here with me, by PK something. And I think that was reported in the Auditor General's report also. Did I mention it here?
This is PFK. BVI Limited, who were engaged to prepare a business case for the initial TPP.
Yes.
Public-private partnership.
Yes, so that was a case you were dealing with at that time, but that was being dealt with through the PPP arrangement, and that would have been the business case, which is what we were relying on.
Help us with this, though. Firstly, that was the PFK document prepared for the project in which you were involved, or the project, the part of the project in which you were involved, or the part of the project in which the Ministry of Finance was involved?
I don't recall the exact nature of that, but I know I was aware of the report, the business case that was prepared.
Okay, thank you. So you've explained, I mean, and you touch on it in your written response, but clearly the BDO report. I mean, if I explain, I mean, one can split up the port development project into a number of sections, and obviously there's the efforts that were made prior to you coming into post as minister. Then there's the period from November 2011 to July 2012 when your ministry is leading it.
Yes.
Then in July through to October 2013, Ministry of Finance has taken over and there's a tender process. And then after October 2013, it goes back to the Ports Authority. So obviously the BDO report is prepared at a time when, whilst the Ports Authority still sit under your ministry, it's now the Ministry of Finance that is leading on the tender project, isn't it?
Always was the case in government. Procurements of that nature were handled by the Ministry of Finance.
But it's 20, just bear with, humor me and let's adopt those different categories of time.
Yes.
The point is that after July 2013, there is a tender process that is led on by the Ministry of Finance.
Yes.
And so by that time, your ministry isn't, if you like, the lead ministry.
Yes, we were the lead ministry, except that we weren't leading in the procurement process.
All right, let's accept that.
I was still the minister responsible.
No, you're still the subject minister.
Yes.
But that's let's accept that distinction.
Yes.
So the BDO document is not prepared for a time. It's not a time when you are formulating or gathering information or preparing a proposal or doing all of the other steps that you, Mr. Skelton-Klein, did. It took you up to July 2012, is it?
Yes.
Because it's dated after that.
Yes, correct.
So you've referred to the PFK document, but other than that, were there any other studies done?
Yes.
You say project appraisal, planning, development proposal, needs assessment, cost benefit analysis, and estimates followed. Well, who prepared those? The Port Authority requested an environmental study be done based on the scope that we were proposing. And the document should be available from the port as to what was prepared in April of 2012. And I don't recall other documents that might have been prepared then, but like I said, Commissioner, the project was at the time the public-private partnership group were the ones making assessments, providing the project. I know at the time there were architects who were involved in designing the project, Roger Downland and co. And there were other persons involved in providing the scope of the project. But that was on the side of the selected bidder, wasn't it?
Yes. Yes, that's what I'm saying.
So if we split it, what your response comes back down to is that you are aware of 3 reports which you've presented, the BDO report and then the couple of others. You've presented a financial evaluation, I think. You're aware, those are that, and then you're aware of PFK report. And then you've spoken of an environmental impact assessment, which was done by, I think, Dr. Cassandra Titley O'Neill. Now that is referred to in the minutes of the PAC meetings, because there was a resolution about it. But that's on one side, that's on government side. And on the other side, what you say is that effectively Tortola Port Partners would have had architects involved, would have had to do a complete analysis and appraisal to submit to government in due course. Is that right?
Correct.
At what point in the process were they going to submit this complete analysis, planning and project appraisal?
It was submitted. In fact, it was even submitted to the point where it was taken to the public. It was presented.
But at what point would that occur? Did that occur?
It was before July.
Before July 2012?
Yes.
All right.
In fact, as I recall, there was a public meeting in March. There were other public meetings, but there was a major public meeting that the plans that were there were presented to the public. Following these are the TPP plans that they were presenting to the public for input that we had, and that was done in March, as I recall.
March 2012.
Yes. On the 27th of June 2012, another public meeting was held about the project. 27th of June.
You're reading from a document, Honourable Vanterpool?
No, I'm reading from some notes I made about the chronology of how the project, how I recall the project.
Right. And where do they? What information are you drawing on to put that chronology together?
From various pieces, but those notes you would find that either would be at the Port Authority minutes or would be at the level of the ministry or would be at the cabinet notes, minutes notes. But
you say you've put that chronology together from various pieces of information. What pieces of information?
I just said from my recollection of cabinet meetings, from my collection of ministry meetings, and from my collection of the public meetings that were advertised. And most of those meetings that I'm talking about, Mr. Commissioner, were press releases, gazetted, and.
But do you have documents that, I mean, if you've got press, if you've taken it from press releases or the Gazette or
I don't have
diary?
Those. I don't have those. These are collections that I have. I know I have basically when we were debating the Public Accounts Committee report, my ministry at that time provided me with a chronology of the project. And that's mostly where it came from.
And do you still have that chronology?
I can provide that if you.
Thank you. Right, I think if we move on to criticism 5. Thank you very much, Honourable Vanterpool. Criticism 5 is this, that the public tender process was disregarded, no public tender or open solicitation for the project, no competitive procurement procedures, no proper or transparent process by which the 3 bidders and contractors were identified or selected, and no assessment made of whether there were better or more cost-effective options available. Now, this, as a criticism, relates specifically, Honourable Vanterpool, to the process at which you were involved, because the process in which you were, I'm going to say you were leading. But November 2011 to July 2022, the process that you take this project through to results in approaches from 3 entities, which then on 27th of March 2012, you sign heads of understanding with TPP, Tortola Port Partners, and that was done without, as a process, there is a lack of clarity as to how how it came about that these 3 entities were asked to make proposals or how it was selected. But what is clear is that in identifying who would be the successful partner in a public-private partnership, you did not put it out to tender.
No, it wasn't put out to tender, but Mr. Commissioner, as you may be aware, Cabinet has in the past and had that they could do select patients or select tendering, and 3 persons were invited to present proposals. Those proposals were presented. One of those proposals was selected as to where we think we would like to go. We did not give a full direction for that group to go forward. They were to present their proposals. We were to continue to receive their positions as to what they would do, and then Cabinet would have decided, which they did in July, as to whether they should go forward. And then once having given direction to go forward at that point, Cabinet asked them to meet 9 conditions precedent, and that was put forward. Later on, they didn't meet those conditions, and that's when we halted the project from their point of view. But that is how it happened.
But there was no public tender process.
And initially, no.
And did Cabinet make a formal decision to waive that tender process?
I don't recall not having access to those, but I recall that that's the direction we were given. The Minister of Finance and myself signed after that the heads of understanding, non-binding heads of understanding, and that's where it reached.
I accept, Honourable Vanterpool, that that's where it reached. It's how it got there that's the question. And just so that we can be clear, because you just said that's the direction I was given. So, did Cabinet? Did you make an application to Cabinet before finding 3 bidders for a tender waiver?
I don't recall that.
Well, it's a multi-million-dollar deal. You're going from inheriting a $12 million deal to one that is now much more ambitious in its presentation. We're talking 50, eventually it gets up to $70 million. So, you know, you not only is your pier being extended significantly so that you can accommodate much larger ships, but in terms of landside development, it's much more ambitious. So surely you would remember if you having to go to Cabinet and say, I'd like a tender waiver because for a project that is going to be upwards of at least $50 million.
Yes, and the process for that the 3 bidders were invited to present to Cabinet. The Cabinet was aware of it. Even the governor and Cabinet at the time with comments that were made in Cabinet minutes that I recall that we did there. And whether there was a specific, and I believe there was, but whether there was a specific waiver of tender at Cabinet, I cannot recall exactly when or how that was, but I know that the Cabinet was involved in the decision.
But did Cabinet issue a decision that the Ministry of Communication and Works could proceed along this route without the need for a tender?
I don't recall exactly that, no.
Because on the evidence, the reason the Ministry of Finance became involved at a point where you had signed, and the Premier accept, but you had signed non-binding heads of understanding with Tortolo Port Partners, was because there were concerns about a failure to follow a proper procurement process.
It is. I think it is accepted that, I don't know what would be considered a proper procurement process, but it was accepted that by that time, the process should have been taken to a wider and a more acceptable bid according to the protocols that were established afterwards.
Well, help us with this then. You have 3 proposals you in early 2012. You have proposals from Carib Invest, Trident Development Enterprise LLC, and Tortolo Port Partners.
Yes.
Who approached those 3 companies?
I don't remember specifically, but I think it was more that those 3 companies approached us.
Who's the us?
The government.
Well,
the ministry. And then we presented those 3 companies to the Cabinet.
Well, you say they approached the ministry. Did they, in fact, was the approach made to you and Mr. Skelton Klein?
I don't recall exactly, but that's possible the case. I met, I think you must understand the context of this. I met many of these persons within the cruise industry and persons who were presenting to us. In fact, when the Tortolo Port Partner Group approached us, it was an approach with the support and direction of the Disney Group, who were involved in the process before. And that is what I recall. Then we invited them to present their case to us, and we, having presented them, we made a selection at a time.
But would a fair summary be that, I mean, you and Mr. Skelton Klein are going out having meetings with different cruise operators, you're going to conventions, you're having discussions, you're obtaining information. Is it possible that you and or Mr. Skelton-Klein would have approached one or all three of these companies and invited them to make proposals?
As I recall, those proposals came to us as presentations, as proposals. And I believe a lot of it was instigated through they were doing before, and then we told them we wanted to change. They came to us through the TPP group as a joint venture. The Royal Caribbean group came to us as a joint venture with a local tour operator who represented Royal Caribbean. I believe that is the Trident group. And then the Caribbean Best group came to us with proposals about the land side of the development. And those are the proposal that became us. How it all began and how they came to present, I just don't recall all of it, if you may allow me, but I know that they came to us.
Well, do you remember giving them information as to what they should propose?
No. And there wasn't an official call going out to invite for bids. Is it correctly so?
I see.
The case.
So you didn't publish an invitation for expressions of interest?
Not that I recall, no.
As a result of conversation, these proposals then came in?
There wasn't a call that way.
I see.
And that's why I say, the change that was made later on, we felt that we should change the course of how we were receiving proposals, and that was done. But
first time round, it sounds extremely hit and miss.
I don't know that it was, well, you may want to describe it that way, Mr. Commissioner, but it was an urgency that we felt, and based on what the cruise ships were suggesting and having them involved, there were several ports that were developed in the Caribbean. The one that we were following to be closely was one that was developed in Falmouth, Jamaica, where there was a proposal made to us as to how this was done, and we felt that was a good course. However, they showed us port developments in St. Martin that they had just done, Royal Caribbean in this case. They showed us port developments that were done in St. Thomas, and there was some proposals that Disney were looking at in the Dominican Republic. Those were some of the scope of proposal that we looked at. And we felt it was urgent to move on because the cruise groups, they sign agreements forward into 3, 4, 5 years, and we felt we needed to get in on it and get on with the project. There was, in my ministry, I know designs and scopes that were developed by a group called CHM 2 Hill document that the government has provided, and as to the port's developments, we followed some of that, and there were some other documents such as those that we are following. But in terms of the pier and the landside development as a combination, that's what we were looking for. Now, the process, yes, it could have been done better, and we adopted that later, but that is what we were looking at the beginning.
Thank you.
CH2M Hill
Yes.
was the technical support that the Ports Authority had in terms of design for the pre-2011 development.
Yes.
Whereas, I mean, that must have been of limited assistance because you were imagining a development on a much grander scale by then, weren't you?
That is correct.
Just help me with this before we move on. July 2012, I think it seems to be agreed that essentially that the heads of an understanding with TPP comes to an end. A decision is made within government to have a public tender process. Mm-hmm. And that is then led by the Ministry of Finance. Now, you're still the subject minister.
Yes.
So to what extent were you then involved in that next phase of the process?
Well, the Ministry of Finance, following that point, went to make and did the tender process. That was done. I'm aware of what was happening there. I didn't have a major role in it, what was happening, but I was aware of it. And that's as far as I know.
Now we know from other evidence, and that includes Neil Smith, the former financial secretary, who gave evidence last week, and evidence before the PAC that Mr. Skelton-Klein was involved in that phase as well. There is some suggestion on the evidence that he was involved in effect to represent the interests of your ministry. Is that your recollection?
That is correct.
If we move on, please, Honourable Vanterpool, just to criticism 6, which reads that the process of stakeholder consultations took place after TPP were chosen as contractors, so preventing input from relevant stakeholders to ensure that the best option was pursued. Now we're again back to the process time between November 2011 and July 2012, when the Ministry of Communication and Works was progressing the project. What you say is before a full agreement was made, following a non-binding heads of understanding, the project as proposed by TPP was submitted to public hearings for stakeholders and public input. So I think that what the criticism is directed to is why this could not have been done before signing the heads of understanding.
Signing the heads of understanding gave us the opportunity to present a project as was envisioned. Prior to that, there was no project that we had that we could go to stakeholders about and go to the public about. Once we signed with TP and said, they said this is what we're proposing, we said to them, take it to the public, let's get public input. That is how we reached that point. Before that, we had nothing to go to the public about. And that's what
So you relied on, when you get to the stage of the heads of understanding stage, your reliance on TPP is to effectively produce something as a proposal that can actually be presented to stakeholders and presented to the public.
That was correct.
So that's their job to do.
It was their job to do and we were involved in the public meeting.
Yes, of course.
So yes, it was their job to present that, yes. And they did.
Now, when you were explaining what the sort of public-private partnership aspect, you said, government has to give them the land, and that they put the money in, and after a period of time, government gets the land back. But in this case, is it the Port Authority that owns the land?
Yes, but they could not authorize the transfer of the land or the lease of the land without government's authority.
Now, when you did that post heads of understanding approach to the public and stakeholders, did it result in changes to the proposal?
Sorry, I missed that.
So
say it again.
What you respond is, well, the proposal, TPP's proposal was put to public hearing so stakeholders and the public could have input into it. Did that process result in changes in the proposal?
Yes, there were different suggestions and ideas that were taken into consideration.
Can you give the commissioner some examples?
I don't recall. There was, some very, very simple ones. There was a big Ferris wheel suggested, and the public felt that's not the London look isn't what the BVI look is. We should have palm trees instead on the coastline. The different things that I recall. There wasn't any particular substantial change to what was being proposed. The taxi association were concerned that, for example, I think that they couldn't be right up to the dock as the guests come off. They were to be a distance away, and they wanted to have discussions about that. Things like those we were entertaining and had discussions on them after. I don't recall any other major substantial change suggested at the time.
If we move on, Honourable Vanterpool, just to the next potential criticism, which says that the Town and Country Planning Department was not involved in the cross-agency consultations solicited for the development. The project moved forward without their input, in spite of the fact that the development involved prime land in the middle of Road Town. Now, again, this is focused on that period, November 2011, July 2012, where you were leading the charge, so to speak. And your response is that you recall at least one meeting with Town and Country Planning in your office. You're reliably informed that the TPP group would have had several meetings with Town and Country Planning, and you return back to the point that Dr. Cassandra Titley O'Neill conducted an environmental impact assessment. Just remind me of this. Would Town and Country Planning sit as a department under your ministry?
No.
Where does it?
The Ministry of.
At the time, I mean,
Yeah.
I think departments and portfolios can move around.
I know it was under the Premier's ministry.
Thank you. And where did you learn that TPP had meetings with the Town and Country Planning Department?
These were information that came back to me from a consultant, and I think that consultant would have been at some of those meetings.
So during that process, was Mr. Skelton Klein having regular meetings with TPP?
Yes.
And even after the bid was, if you like, their proposal was accepted, did those meetings continue?
They certainly the idea that we were trying to develop exactly what would be the final product. There were meetings with them, yes, and I believe that some of those meetings were with Town Planning Department, as I recall.
Did you say? Obviously you have a recollection of at least one meeting that you attended. How involved were you in meetings with TPP and the Town and Country Planning Department?
I only recall, as I said, one meeting where there was a discussion in my office about the project, and it had a lot to. It was surrounding not just with the player development, but the city's development in relation to the project, traffic, and that kind of stuff that we were looking at. That concerned me as minister in terms of what happens in the city, and the city came under my purview at the time also.
Yeah. Now, when you obviously November 2011, you begin, as you say, gathering information. How early in the process did you involve Town and Country Planning?
I don't recall exactly how early. It certainly wasn't November, December, or January. I can't recall after that. It might have been soon after that when we did.
So the best you can do is that sometime after January 2012, Town and Country Planning Department would have become involved.
Yes, and it was mostly, if I may, Mr. Commissioner, after the proposal of what the project would have been is when we started engagements in that direction.
So once you had a clear idea from TPP of what they were going to build,
yes,
that's when you started discussions.
Yes.
Well, let's move on to the next criticism, please, Honourable Vanterpool, and that is that to the knowledge of Honourable Mark Vanterpool, there were serious flaws in the proposed project development agreement, the heads of understanding agreement, and the ground lease as between the BVI government and TPP. Now, I think I'm going to ask you just to turn up the 533, which is the Auditor General's report. Yes, you should have
That's in the second bundle. Okay, sorry.
It's in the first bundle, right at the back.
Oh, okay. Yes, 533.
Thank you.
I think I'm with you.
It's under a heading independent legal review. Can you see that?
Yes.
And what you've said in your response is that you were not aware of any serious flaws in the drafting of such documents. So no one brought them to your attention.
I was not aware.
And you point to that. I just want to clarify that just whether there's any typos in the next sentence, because you say, as I understood it, these were negotiations between the Attorney Generals and TPP. That's right, is it? Yes.
Once the heads of understanding was made, the agreements were turned over to the Attorney General for negotiation and discussion. They were the ones who were leading that. So yes, that is not a typo. Where were you suggesting might have been a typo? Sorry.
I'm not suggesting it is a typo. I'm suggesting I just want to be clear that there isn't a typo. So
Yes, yes.
the first sentence of your response is that you were not aware of any serious flaws.
Absolutely not.
The second is that, as you understood it, these were negotiations between the Attorney General's chambers and TPP. And you then go on to say that a UK firm with expertise in public partnership agreements then became involved.
Yes.
It's just that allows me to then take you to 533, because at paragraph 42, what's recorded in the Auditor General's report was that throughout the process, the Attorney General's chambers was consulted with respect to the government's interests. All of the legal arguments, however, all the legal documents originated from the developers' lawyers, that's from TPP side. And in June 2012, the Financial Secretary sought independent legal advice from specialists in public-private partnership, which was Baker & McKenzie in the UK. And they reviewed the project development agreement, the heads of understanding agreement, and the ground lease, and raised a number of concerns. So the concerns were raised in or around June 2012 by Baker & McKenzie.
Yes.
Following, it seems, instructions from the Financial Secretary. But were you at that point, was any of the concerns that Baker & McKenzie were raising drawn to your attention?
Yes, I was aware of them. They brought, I was aware as a minister, yes.
Because what they are identifying, Honourable Vanterpool, is serious flaws in the project development
Yes.
agreement, the heads of understanding agreement, and the ground lease.
Yes.
You're saying you're now aware, you were aware, but how does that reconcile with your first answer, which was I was not aware of any serious flaws?
I think you're misunderstanding. Let me be very clear. I was not aware of any serious flaws because I was not involved in the discussion and the negotiations with the Attorney General office and the group. It was felt that the Attorney General, in fact, the Attorney General office expressed their view that they didn't think that they were sufficiently equipped to handle public-private partnership negotiation and disagreements. And therefore, we made a determination to the Ministry of Finance to hire Baker McKenzie Group to advise on the matter. When that group came to the BVI, they met and made negotiations and pointed out to the government certain matters that the government needed to be aware of. I was a part of that government, I was a part of that group that would receive those commentaries from Baker McKenzie Group. And that is the time I became aware of flaws. So, but I'm saying the original, which is the indication of what the criticism said, that originally I was aware of these flaws. I was not.
We see. So we can distill it down to this. When the Attorney General's chambers was involved, you were not aware of serious flaws. After Baker McKenzie were instructed by the Financial Secretary and undertook a review, you then at that point became aware of the flaws.
Yes, that is.
Thank you.
That is my evidence.
All right, let's turn to the last criticism, or potential criticism, I should say, is that there was a concerted effort on the part of Honourable Mark Vanterpool to obscure information regarding the processes undertaken on this project from the Public Accounts Committee. Now that obviously flows from the report of the Public Accounts Committee, and in fairness, you should have an opportunity to respond to it. And you gave some comments about the process undertaken by the Public Accounts Committee on the last occasion you gave evidence, but you say now that you strongly deny the validity of this potential criticism. All persons under your authority were asked to fully cooperate with the Public Accounts Committee. I was not summoned to the Public Accounts Committee. However, I made several statements to the House of Assembly and answered the Public Accounts Committee report through the House of Assembly. May I just break that down a little bit with you? Was there any reason that you know of that you were not summoned to the Public Accounts Committee?
I don't know of any specific reason, Mr. Commissioner, but I don't think it was normal that, and I don't think of any instance before where a minister was summoned to the Public Accounts Committee, at least here in the BVI. But certainly, if I was summoned, I would have been happy to go and give evidence. But I don't recall, I don't think it was normal that that happened.
Right, so is there, if you like, a convention in the House of Assembly that you don't summons the minister to come before the
I don't know
committee?
if there's a convention, but I don't think there was precedence
I see.
But certainly, once the report is prepared, the minister gives a comfort in the House, which is what I did.
And so there was a debate in the House of Assembly.
Yes.
And you then responded on the recommendations and conclusions of the Public Accounts Committee report.
Yes, I did.
And would a fair summary be that there were aspects of that report that you did not agree with?
Absolutely.
And did you, just going back to actually the potential criticism, so in terms of persons under your authority were asked to fully cooperate, did you make that request of them?
My view, Mr. Commissioner, was that a public accounts committee is conducting an investigation of a project like this, and it would be, I think it would be, I don't want to use the word foolish of me, but it would be, you know, not proper of me to try to stop someone from doing that, and I didn't. That would not be my modus operandi.
But did you tell, you know, officers in your ministry,
not necessarily,
you must cooperate?
No, well, officers were summoned and they went to the meeting. It was not for me to tell them to cooperate or not, but I certainly did not prevent them. I was happy that they went and gave account. I don't know where that if somebody could present some evidence to me that I tried to prevent it, I'll be happy to defend it. But it just said it says so in the criticism. Nobody's giving me any evidence of where that might have happened. I was actually surprised about that.
Well, I think it's a conclusion of the Public Accounts Committee.
That's what I'm saying. I don't know a conclusion on what basis.
Well,
if there's no basis, there's nothing for me to answer.
On the evidence that they gathered.
What is the evidence that I did it? That I prevented? Give me the evidence.
Well,
what is the basis of the evidence? They just said so, or there was a basis that showed that I prevented anybody from giving evidence to it. I would not have done that. But if there's a basis, I'll be more than happy, Commissioner.
Well, the wording is to obscure information, but what you're saying is,
where's the basis for that?
Well, again, Hon Vanterpool, what the letter does is to give you all of the evidence. You've explained today.
Yes, I appreciate
that you've been through it. You've also explained today that you responded to the Public Accounts Committee in the House of Assembly. You've also explained today that you wish to just respond on the basis of your written response rather than getting into a position where you might either be seen to be accepting or agreeing with other people's evidence.
Yes.
But can we, in terms of focusing on what you did at the time, is the position this, that where you say all persons under my authority were asked to fully cooperate with the Public Accounts Committee, you did not in fact ask any official or person in your ministry to fully cooperate with the Public Accounts Committee?
As long as I know members of my government under my purview are going to give evidence, I would encourage them to give the evidence, yes.
Did you instruct officials to provide all documents to the Public Accounts Committee that you actually formally gave that instruction?
No, I don't know what you mean by formally. I didn't write to them or tell them to do it, but I know that if there was someone, I would say to them, go and give the evidence.
You relied on the professionalism of the officials in the ministry to behave properly when summoned to a committee of the House of Assembly.
The Public Accounts Committee is a very serious committee of the House, and anyone who's summoned, if I was summoned, I'd have to go myself, but it's not. It's obviously it wasn't the president's, but I think it's a respected committee that has to be given. It's a committee that is political, and I must make that clear. And that's why I said at the end there, unless there was evidence that I tried to obscure, and there was a report that comes to anyone that says the minister tried to obscure information without giving evidence of what that was. I don't even consider it to be a report. That was my position, because there's nothing to substantiate that I tried to obscure. I'm answering 9. There's nothing that suggests that I tried to obscure information. If there was something, I'd be happy to respond to it. I don't even think it's dignified to give a response to that, to be honest with you, Mr. Commissioner.
But in terms of your dealing with the BVI Ports Authority, would they be persons under your authority?
The BVI Ports Authority?
Yes. Would you describe the board of the BVI Ports Authority as persons who fall underneath your authority?
Not necessarily my authority, but they would, because the board is appointed by me or by the government. they should be encouraged by me to give evidence.
Well, did you in fact encourage them to give evidence?
I don't recall specifically that I had to. I think most of them gave, as far as I know, and gave freely. I think they gave freely. From my
so once again, it comes. I mean, you were content to rely on the professionalism of those summoned,
yes,
that they would
certainly, Mr. Commissioner,
give evidence freely, supply any documents that they were asked to, and cooperate fully with the Public Accounts Committee.
Certainly, Mr. Commissioner, certainly.
Commissioner, I think I've reached the end of my questions. Could I conclude by thanking Honourable Vanterpool for making himself available today, and also for the way that he has given his evidence to the Commission today?
Thank you, Mr.
Yes,
Commissioner.
can I echo that? Thank you, Honourable Vanterpool, for coming and giving the evidence in the clear way that you have. As I said at the outset, if there's anything arising out of the cabinet papers that you now have, if you could let us have anything on those by the end of the week, that would be appreciated. And we'll now deal with the law with Mr. Denniston Fraser.
Thank you.
You can go or stay as you want.
I think I'll leave you good legal people to have your.
Very good.
Thank you very much, Commissioner.
Yes, Mr. Rowett, do you want to open this?
Certainly, Commissioner. One of the issues on which, or the issue on which you asked for assistance from the legal representatives of Honourable Vanterpool was the question of the operation of the Ports Authority Act.
Yes.
You'll recall, Commissioner, that on the last occasion that Honourable Vanterpool came to give evidence, he relied on the Act, and he sought to address you during the course of his evidence as to the ambit of the Act and the extent to which it allowed him to operate as a minister. As you have explained today to him, that is not a matter for him, but a matter for legal submission. And if I could perhaps just introduce, I think, the issues that may arise.
Yes.
You'll find the Act at page 496 in the second volume of our Law and Constitution, not that volume, Commissioner, but I think one of the volumes that is now sitting on the floor.
I'm sorry, is it volume 2?
Volume 2, to be. So page 496 is the first page of the Authority Act 1990 as amended.
Yes.
Yeah, it was amended in 2017, and the amending statute is in the bundle at 568. But the amendments are not. Don't change substantially the issues with which we have discussed. What they simply do is where the words legislative council appear, that becomes House of Assembly. Where governing council appear, it becomes cabinet.
Yes.
But to just set out some of the key provisions that I think may arise today, section 4, which you will find at your page 507. Sets out the functions of the authority. Perhaps if I just draw your attention to section 3, Commissioner, that section 3 establishes an authority to be known as the British Virgin Islands Ports Authority, which is a body corporate which can sue and be sued in that name and perform such acts as body corporates perform. Section 4 sets out the functions, which include at 4A to provide, operate and maintain all port and harbour services and facilities in the territory as the minister considers necessary. and at B, to take such actions as the authority considers necessary in relation to the exercise of any of its functions mentioned in paragraph A. Then at F, for F, which is something I think Mr. Learned from Mr. Fraser may take you to, and that is to perform such acts as the minister determines and report to the minister at such time as he requires, respecting the matters to which this act relates.
And 4E as well.
Yes, to develop and manage all lands, including lands or under the seabed leased to or vested in the authority.
Yes.
The Act gives the authority certain powers. I don't need to set out the detail of those, but you'll find that there is section 5 says, without prejudice to section 4, in the exercise of its function under this Act, the authority may, and then it sets out various powers that the authority can exercise. It also has, and we don't need to go to the detail of the specific provisions, but at section 6, the authority has powers of entry on land or building. Section 7 establishes or gives the authority its own funds. Section 8 allows the authority to borrow which under section 9, such borrowings can be guaranteed by government. Section 10 gives the authority power to borrow from government. And section 12, which is at page 515, allows the authority, with the concurrence of the minister responsible for finance, so not necessarily the minister under which the authority sits, but rather the Minister for Finance, to invest funds that are to the credit of the fund. Also, just briefly mention sections 20, which is at 518, where we have the authority, with the approval of Cabinet, being able to appoint a managing director and a deputy managing director. And at section 21, which is at 519, having the power to appoint on such terms and conditions as the authority may determine such other officers and employees as are necessary and proper for the administration, management and performance by the authority of its functions under this Act. I've left out perhaps the second key provision that Mr. Fraser may wish to draw you to, and that is at 19.1, which is that the minister may give the authority general directions in writing as to the performance of its powers under this Act on matters which appear to him to affect the public interest, and the authority shall give effect to such directions. So I think perhaps, as I understand Mr. Fraser's written submission, there are two key provisions that would justify, for example, Honourable Vanterpool being able to give very clear and specific directions to the Port Authority, and where, even if one takes it as an extreme, that taking the lead and presenting the Port Authority with a decision that is then required to make would be justified in law by Mr. And it's firstly, it's 4G, which we've looked at. But in my submission, the difficulty with that, sorry, it's 4F, I apologize. The difficulty with requiring or a minister being able to dictate that the Port Authority can perform such acts as the minister determines, is that that cannot be interpreted and cannot be used by a minister in such a way as to prevent the authority from fulfilling its other functions under the Act, and nor can it be used to compel the authority to do an act that is outside its prescribed functions. As to section 19, which was the section that Honourable Vanterpool drew your attention to on the last occasion, but also in his written response, and no doubt from which you will want to hear from Mr. Fraser on. Firstly, the minister is limited to giving general directions. There is no definition in the interpretation section, which is section 2 of the Act, as to what is meant by general direction. And in my submission, perhaps it can best be understood by looking at the factual circumstances and asking whether it could, on sensible analysis, fall within the term. For example, in my submission, directing a board to sign a resolution could not be described as a general direction. It would fall more readily being a specific direction. And in fact, during the course of his oral evidence today, Honourable Vanterpool did refer to specific directions. The second is that the directions must be in writing. But the third is that any general directions given must go to the performance of the authority's powers under this Act, which appear to the minister to affect the public interest. So what the minister cannot do, unless it can be justified under section 4F, is give general directions in writing, or even specific directions in writing as to the functions of the authority. The phrase performance of its powers under this Act take us to the specific provisions which refer to the powers of the authority, in particular section 5, which is headed in the marginal powers of the authority. And the added qualification to any direction given as to the performance of powers is that the minister must, on a reasonable analysis, come to the view that such direction is needed because to do otherwise, because it appears to affect the public interest. So there are, I think, a number of hurdles to section 19. Firstly, it must be a general direction. Secondly, it must be in writing. Secondly, it can only be directed to performance of powers under the Act, which is set out in other sections. And thirdly, it must be on a matter which the minister has concluded affects the public interest. That's all I propose to say by way of opening the position, and I shall cede the microphone to Mr. Fraser.
No, thank you. Yes, Mr. Fraser. What do you say? Your submissions, understandably, are focused really on section 19(1), although you refer to other provisions as well.
Right. Section 19(1) was the important section we thought there. We just wanted to clarify in writing and exactly what that meant. And it is clear. You've mentioned section 4 of the Act, and we understand and recognize that the authority has certain functions, and we do not expect the minister to usurp the functions of the authority just by giving section F of section 4, F of section 4. So we totally understand that, but section 19, which we focused on, and I know the contention is whether or not in writing, whether or not this is something that the minister should have done. Well, I contend that the in writing portion of this does not necessarily mean an instrument signed by the minister under the minister's hand in writing. This could have easily come by a letter penned by the permanent secretary, those advising the minister to any person. It may have been certain discussions that the minister would have had with the permanent secretary or any particular consultant, which further to those instructions, the PS or the consultant would have then deduced that in writing to the board or to the authority itself. But it doesn't necessarily mean an instrument under the minister's hand, under the minister's signature.
I understand that, but there's no evidence of any of that.
Exactly. So what I'm saying is these additional any additional evidence that will show that the minister did give directive to the board or to the authority would be considered or should be considered in writing as well.
But if that's right, there's no evidence of the permanent secretary giving instructions in writing, nor indeed the consultant.
Well, certainly we had, additionally, we did have minutes that were given or noted, I should say. The minutes of any board meeting, once that's communicated in the board meeting, the minister's prerogative or the minister or the government's view on a particular matter, if that was discussed in board meeting, or if the PS had noted that in a board meeting, or if the minister came to a board meeting and he explained that to the board, the minutes of the board would suffice as evidence in writing. And of course, as we've noticed throughout the Act, the minister has been given various prerogatives, as I mentioned in section 7, I think it was 7.5. But we want to, and that's just to show the totality of the Act, where the minister is not hands-off, basically. The minister is hands-on in terms of giving certain directions to the board. But we focus, of course, primarily on the section 19, section 19, where it gives, where it speaks about the minister having that responsibility.
Well, yes, but he may give the authority general directions as to the performance of its powers. Well, as Mr. Rowett said, we're really concerned with not the powers, but the functions of the authority as given to the authority by the legislature, and that includes, for example, the functions of the authority shall be to provide all port and harbour services and facilities in the territory. So that's a function, he can't interfere with that. And the power, which perhaps is particularly, or one of the powers which is particularly relevant, is the power at 5H, that's to enter into an agreement with any person for the construction, other things as well, but the construction of any property, real or personal. But that is which, in the opinion of the authority, is necessary or desirable for the purpose of discharging any of its functions. So even that power is constrained or defined by, in the opinion of the authority. So that's not something which the it seems to me the minister couldn't arguably override by section 19, because he can't override, he can't tell the authority what its opinion is. So that's this part of the functioning of the authority seems to me to be inherently embedded in the Port Authority Board.
And while we agree that is so, the Ports Authority Board has that inherent authority. It doesn't negate the fact, again, back to section 19, about the general scope and the general directions, as it says, as to the performance of its powers under this act. And especially where it talks about which appear to him to affect the public interest, and the authority shall give effect to such directions. So again, having the overarching authority to give these general directions, we're not expecting the minister to go and direct or instruct the board or the authority to sign a particular agreement or resolution and so forth, but we expect him to at least give that overarching direction, and which I think he clearly pointed out today as to where the government or of the day would have wanted to take a particular.
Oh, the policy direction, that's clearly a matter for government, but it's whether implementation of that policy by going out as Honourable Mark Vanterpool said he did, and identify the contractors without any proper procurement process, to negotiate with them as to precisely what's required, and then to present the board with a proposal, and eventually to require the board to sign heads of agreement. Do you say that all of those fall under section 19?
I would say that it is unfortunate. I know we did request from yourselves, well, we did request to cabinet to have a copy of maybe minutes, decision notes.
I mean, and we and you will have those this week.
And thank you. And I did read an email that came in early this morning and said that they will be placed in the Dropbox.
They'll be there, yes.
One of the things coming out of the meeting this morning is, and which I would let you know that we probably would seek to pursue, are the minutes from the Ports Authority Board. Those minutes during the period November 2011 up to maybe the entire 2012. I think that would add additional information and give additional evidence as to exactly what transpired in that process. We do not have that evidence before us.
No, what we've got is we've got the PAC report, which did have that evidence and also took evidence from the individuals involved. And they said, I think to a man and indeed woman, that they were cut out of the process.
Commissioner, you said you had two types of evidence, one from the reports and one from the...
We've got the PAC reports
PAC.
And the evidence given to the PAC.
Right, and that's fine, but I think it's very important that we see the actual minutes of the board itself.
And I don't think we've got those.
We don't, Commissioner, but may I, I'm sorry to intervene, but
yes.
Can I just respond on that whilst I still have it? What we have is the two reports issued by the Public Accounts Committee, including their final one, and to both there are minutes of what is described as meetings, but it's actually appearances of witnesses before the committee, which include a significant number of former and current members of the board. That Mr. Skelton Klein appeared, as did the former managing director of the Port Authority, a former and current chairman, and members of the Ports Authority. And so when one looks at the evidence, you have directly from those involved evidence that covers the entire period of the Ports Authority project. But in my submission, what that adds in terms of detail, and which perhaps may not be found in a minute or a signed resolution, was the circumstances in which people say they came to sign. And what the evidence brings up is firstly that from different members of the Port Authority that they were not involved in the decision-making process. They were simply used to ratify decisions because they had to do that, because in effect they were signing the checks. Secondly, that there are at least two instances, I think the evidence of Mr. Adams and possibly the evidence of Mr. O'Neill, where they speak of having to go along with the plan because it was government's plan. And that's what founds the basis for the conclusion that is set out in the Auditor General's report, but also by the Public Accounts Committee, that the Ports Authority Board were essentially sidelined. Matters only came to them when there was a time to effectively sign on the dotted line. And it's, I think the issue, or one of the issues for you, Commissioner, is, well, how did we get to that point? And a minute of a meeting or a resolution that is signed may not necessarily illuminate it.
There's some force in that, I think, and also the submission that we go and look at the Port Authority Board minutes, as it were, cuts against the evidence of Honourable Vanterpool in this way. All of these things, he thought he had power to do under Section 19, so that if the board were not cut out, it wasn't because of the ministers belief in his own powers. It would have been entirely fortuitous. He thought he had the power to cut the board out of all of these things because he thought he could use Section 19 to give them directions as to all of these functions.
I'm not sure if that's what I gathered from the minister this morning in terms of he had the power to cut them out. But to give the general directions as stated, the statement earlier about the we're just acting basically quote unquote as a rubber stamp for the minister. I find that, you know, I myself have sat on boards before, and I don't ever recall a minister, and that was under, it doesn't matter really which government, for a minister to just give an instruction to the board, and then the board would just go and carry out that. For example, as we were mentioning here about signing agreements, of course, this is something that the board would have to look over and consider and decide whether this is in fact something that we ought to sign.
Because otherwise it would be improper and unlawful because they're an independent body.
Exactly.
But I mean, the minister in his written, the Honourable Mark Vanterpool in his written evidence said, we, that is he, and Mr. Skelton Klein, immediately began to gather information and invite proposals for a suitable pier expansion and landside development. However, his intention was to develop the scope of the project, receive proposals, establish a heads of understanding, then present the project as proposed to the Port Authority and the public for consultations and suggestions. So
there is a time period there, I think, in the beginning where the minister mentioned of the basically gathering the thoughts of the ministry and the going forward, looking at the general, he mentioned the, not constitution, but the mandate basically of the party at the time, what was going to happen. So I think the details as to when the general direction was formally made to the authority may be worth looking at, but I think generally the minister in his quest to steer the board in one direction or not is something that was done formally in writing, maybe not in the time frame that that needs to be, but I think generally the minister did through the minutes, through the, as he mentioned, his discussions with the relevant personnel did comply with the act in terms of his general directions.
But the policy he was pursuing was the policy to have a bigger pier with landside development. That was the policy. That was the policy in the manifesto and the policy he pursued. But the implementation of the policy, which on the face of it under the Act is a matter for the Ports Authority, was something that he took over, didn't he? Because from the passage I've read out, it was his intention to get to a heads of understanding on a project with, you know, some detailed proposals that could then be put to the public for consultation. Isn't that the job of the Ports Authority?
Could you just refer me to the criticism?
Top of page 3 is his Honourable Mark Vanterpool's response that I was referring to. But it was reflected in his evidence today. He wanted to get a complete proposal done and dusted with a particular contractor and put it in front of the public for some form of consultation. Well, isn't that the Port Authority's function under the Act?
I honestly think that gathering the information as it states, to look at the scope of the project, changing the scope of the project. I mean, that I think is paramount, that the project went from, a small project, let's say, to a much bigger project. That is definitely not something that the authority itself would do. That is something that's the general direction that the minister would have his say in, of course.
That may be right, but you have to read the words in between, and that is invite proposals for suitable peer expansion and the landside development, receive proposals, establish heads of understanding with a particular contractor, then present the project as proposed to the Ports Authority and the public for consultation and suggestion. And looking at that as a whole, the question is that under the Act not clearly a matter for the Ports Authority? Because it strikes me that given the Ports Authority is an autonomous body, what was it there to do in respect of this development?
To take a project like this forward, I think receiving proposals, we'll talk about the scope of the project, receiving the proposals, establishing a heads of understanding, which I know later on the premier at that time and the minister had signed, that again, establishing it, it's that heads of understanding could have been signed even by the Port Authority itself. But I think what is said here is it's clear that his intention was to develop the scope, receive proposals, establish the heads of understanding. I think again, that is not taking us to any particular minute, as I might say, manipulating the project or interfering in the board's matter. These again are general stuff that must be done. The proposals must be received before anything else could be done. The heads of understanding could be signed. There must be a review of the scope of the project. I honestly can't see any micromanagement in this here, but rather general policy directions given that needs to be done prior to establishing this project.
Thank you, Mr. Fraser. Anything else on that? Thank you very much, Mr. Howard. Anything else?
Nothing further from me, Commissioner.
Well, I mean, I'll obviously have to consider those, and the question is not really so much it is the construction that Honourable Mark Vanterpool took of the provisions in the Act without taking any legal advice, not whether they're definitely correct, but whether they frankly could possibly be correct, given the scheme of the Ports Authority Act. But I'll certainly take those submissions, those helpful submissions into account. Thank you very much, Mr. Fraser.
Thank you.
Anything else, Mr. Rawat?
No, our next witness is due at 2 o'clock.
Good, thank you very much.